Good morning, everyone. My name is David Leach. I'm the associate or one of the associates in the employment team in Sharpe Pritchard. And today we're going to be talking through about the new Worker Protection Amendment of the Equality Act 2010 in relation to preventing sexual harassment in the workplace. And I may be joined by my colleagues Julie and Kit, if obviously they've also got insights that they wish to share as well. So what today we're going to do is have a quick little background on the bill, the current law, the changes to the bill at the time before it became the Act, and then looking at kind of the impact and what employers need to look at going forward. And then finally, just some case law on existing cases in relation to harassment in general, and just how this can be looked at to support HR professionals and obviously employers in general going forward. So the bill was passed and became enacted in October 2023, and is due to come into force on or around the 26th of October this year. And it introduces several changes to the Equality Act. But the main thing really here is that we're looking at is it takes claims in relation to sexual harassment and shifts it from really a redress to prevention. So in the sense of, rather than just having a claim where you can seek compensation for suffering sexual harassment in the workplace, it's kind of pushing it on employers, as we all know, to kind of preventing that, so that you never need to have the redress situation come forward. So obviously at the moment, as most people know, employers are vicariously liable for discrimination in the workplace that's conducted by an employee in the course of their employment. And obviously to be safe from this, they obviously have to show what's called the all reasonable steps defence, in the sense that they have taken all reasonable steps to prevent that employee in the course of their employment from taking that particular discriminatory act. And what might be considered reasonable steps, including equal opportunities policy, anti-harassment, bullying, training, and things like that. I mean, one of the main things really is that this should never have been static sort of training or intervention by an employee. I think we don't really have them anymore, but kind of that poster on the wall that says, don't do this, don't do that, isn't really enough. Employers have always really had a duty to make sure that their employees are behaving and know the behaviours. And obviously, many of this can be found in multiple policies, social media policies and things like that. So that's really the current position that employers have. A quick look at what was going to be in the bill, and I think some employers will probably say thankfully isn't in the bill, was that it underwent several changes, and the two significant ones really was it took away the all reasonable steps and just made it reasonable steps for preventing sexual harassment in the workplace. And also took away third-party harassment, mainly because I think businesses were worried of, it was an open door on what really would be covered by this new piece of legislation in respect of employees suffering harassment, mainly obviously sexual harassment behaviours from anyone and everyone, and how can you really protect against that? And the all reasonable steps is a slight watered down, obviously, to reasonable steps to prevent that, but obviously trying to balance the obligations that the government or the previous government wanted to have on employers to protect its employees, but also not making it an impossible challenge to actually undertake that. So the main thing really is it's the preventative duty, and it is shifting beyond reacting to complaints, and requires employers to take steps from this happening in the first place. But also what was brought in or will be brought in is a new ability for the Equalities and Human Rights Commissions to also bring complaints against employers. It's not just going to be the employees now that can obviously add this into any tribunal claim, for example. The commission can do so itself. And also employers really should be now actively assessing risks and implementing necessary measures. I mean, obviously none of this really is new. Employers should be doing that anyway, but I think it's certainly making sure you are very much focusing on, at the moment, the sexual harassment element of things and seeing what is taking place in the workplace, and what should be being done. So things such as, anti-harassment policies, clear reporting procedures, training and awareness programs for employees, and I'd say training and awareness programs for all employees at all levels. This isn't just frontline staff. I mean, this extends all the way to the top. And there are certainly things, it's adding the layer of financial risk that there could be a secondary set of claims from the commission against the employer as well. And you really should be looking at what areas. So, for example, the traditional workshop floor has always been used as an example of where there's been certain behaviours that people have complained about. But obviously, it's not just linked to that. I mean, the finance industry, for example, is rife with it. There was a recent report called "Sexism in the City," which did highlight both, the equality that women are suffering in the workplace, and also the forms of harassment and sexual harassment that women are also facing. So it is across all employers, across all industries, that people really need to be paying attention. And then obviously, as I said, it originally wanted to reintroduce or reintroduce protection against harassment by third parties, such as clients and customers. This was scrapped mainly because, as it says there, it probably went very far and wide as to how this actually would have impacted employers, especially employers who have a large front-facing element of their business. And certainly, obviously, people like local authorities or organisations like local authorities, shop owners, people like that, are regularly interacting with members of the public and their customer client base, that this could have posed a significant concern for them to actually manage this situation appropriately. So, as we said, what is really going to be the impact? Well, from October, if there's claims for sexual harassment, the main thing really is there can be a boost in compensation of up to 25% if it's found that the employer has failed to take all reasonable steps to prevent sexual harassment in the workplace. Now, it's not a freestanding claim. You can't bring just this in the employment tribunal. You'd have to bring it in relation to other claims. But obviously, at the end of the day, this would be being faced with that anyway. If you've got an employee who's bringing a sexual harassment claim or harassment based on protected characteristics of sex, I should say, in the employment tribunal, that claim's already there. They'd then just be adding this on at the end, a bit like when you see the ACAS code of conduct. Did the employer reasonably follow it or unreasonably fail to follow it? Or the employee as well, whether you get an uplift or downlift in the compensation that's awarded there. So it probably will act in the same sort of way going forward. But obviously, it's another multiplier in relation to tribunal payouts going forward. So it's just something to really be careful for. And it doesn't just apply to harassment based on sexual harassment or the protected characteristics of sex. It will apply to all of the claim, really, certainly the harassment element of the claim. So you could have a multiplier on multiple things to be careful of. So I think it's just looking out for that. And obviously, the employer still might be liable under existing legislation if they fail to adequately deal with complaints in relation to third-party harassment in the first place and fail to put in preventative measures. So whilst third-party harassment in and of itself is not going to be there, if you are aware that this sort of behaviour takes place and haven't done preventative measures or haven't looked at protecting your staff, you could still suffer from these complaints and potentially an uplift anyway. So I think it's just be careful. It's not a get out of jail free card. It's saying, oh, it's a member of the public who's just walked in and harassed my staff. You need to be looking at if this is a regular occurrence, or you're knowing that this could happen in that part of work, then you need to be careful. And I think just quickly, one thing to touch on here really is we had a question as to whether this applies to volunteers, and the Equality Act doesn't apply to the volunteers really. So it's in itself not really something that's there. Now we have a new government, whether that might be on the ticket for change, we don't know. But at the moment, the Equality Act doesn't apply. But also in third-party harassment and so on, it's again, as I've just said, itself not really there, but it's at the same time, if you know about it, it's going to happen, or it's happening regularly and you've done nothing about it, the tribunals are not going to look favourably on that because you've been well aware that something is taking place. So ultimately, really, what does it mean for employers, and how can you prepare for the Act, and then when it comes in October this year? So firstly, reviewing of policies. So I think really sitting down, looking at what your policies do, all of your policies, are they actually fit for purpose? Are they up to date? Are they clear? Are they comprehensive? Does it outline the type of behaviour that you really want to stop? And is there a clear and easy way that employees can report concerns? And what are the consequences for violating these policies? And really, if you don't have certain policies in place, which I would be surprised if anyone really doesn't, you really should be looking to implement one. And also, how updates this policy is communicated, especially if there's been significant changes to the policy. How is this communicated to all of your employees? Is it just updated centrally, or is there a bit more of news and training that comes with it? And then secondly, providing training. Obviously, most places will have mandatory training that all employees must do, certainly during their onboarding and when they start. But obviously, this training should be from senior managers all the way down to your new starter at the very first job they've ever done, and at the beginning of their career, for example. And actually, is that training fit for purpose? Is it up to date? And is it covering the correct sort of topics, and so on? And I think with that training is maintaining records of people doing that training. I mean, we obviously all get occasionally emails saying you've not done your training. Please, can you get it done before this deadline? Is that deadline actually a hard and fast deadline? And if someone doesn't comply with it, you're looking at the reason why. And is there any further action that needs to be taken, or is that just a kind of pin in the calendar? They didn't do it, oh, it doesn't really matter if they don't complete it. And obviously, in relation to sexual harassment and preventing it, that's not really going to ever be good enough going forward. And also, if you are doing open training, so in a room rather than necessarily something online, you listen to a presentation and answer some questions. Is it an open dialogue? Do you have these sorts of discussions with your employees so you can understand, find out where there is potentially lack of training or lack of understanding, so that can be targeted. Handling complaints. I mean, obviously, I think the first point really is the complaints should be taken seriously. And establishing a clear and confidential system for employees to raise these sorts of complaints. So, do you have workplace champions, which obviously is mentioned at the bottom, is one idea of doing that, or is there another way that an employee can raise securely that, or safely, they believe they have been subject to what they think is sexual harassment, or online tools, or any other form of reporting that can help, and then taking those complaints seriously, actually investigating them in a fair and impartial way, and doing so promptly. I think we can all count on multiple hands when complaints have been received in relation to any matter really, and employers have been slow off the mark to actually investigate them, has created a bigger problem. So I think it's just, again, certainly with things like this, proactiveness is key to everything. Encouraging open communication, so obviously creating a culture of open communication where your employees feel safe to speak up about inappropriate behaviour, challenge people on their behaviour, and without the fear of retaliation from their employer. I mean, you still hear stories nowadays of I challenged my employer because I believed I was sexually harassed, and then suddenly I was managed out of the business, or I was ostracized from my team, or I was off sick for 6 months and no one ever spoke to me. There are multiple occasions where this happens and really shouldn't be happening in this day and age. So really, I think that is also the key thing. If you have an open environment where people can challenge behaviours and work together, the instances are unlikely to actually occur in the first place. And as part of that is regularly reviewing things and feedback from people, so you can at least understand what is going on in your workplace. And obviously, each workplace is going to be different in what an open culture will look like. And then also this then leads into identifying the risk areas. This again is going to be a fluid piece of work, because one person's risk area is going to be hyper risky, and another person's it won't be, because potentially they haven't got that type of working environment. and things might be, where you've got long hours of people working, certainly late at night in the office. Again, that's potentially looking at the finance industry. Is they've got really long hours. They're all working in confined spaces, and inappropriate behaviours have come out of that. Also, is there roles where there's severe disparity in power between the manager and the person involved? And looking at the legal industry, for example, there are still issues going on in relation of partners, senior partners, and very young trainees, and inappropriate behaviour taking place in relation to that. So it is places to look at and where that might be. And then finally, workplace champions, as I said before, really kind of one of these sorts of sources for employees to go and talk to about if they have concerns. I mean, certainly like at Sharpe Pritchard, for example, we have mental health first aiders. They are people that you can go to, and they are at all different levels of the organisation if you have a mental health concern. So it's again something akin to that. They are identifiable people within a business who an employee can go to speak about these sorts of things, raise it in confidence, and know that there is a reporting structure behind that can help them if these matters kind of escalate or are a serious concern and need to be addressed. So looking at incorporating the new legislation, so obviously certainly scheduling your policy reviews, targeting the policies that you need to deal with. I mean, obviously trying to do all of your policies at once, I think, is taking a bigger bite than necessary, but certainly targeting your important ones, any anti-harassment or anti-bullying or dignity at work policies, your critical ones, and then looking through all of those to see if they need to be updated, and does training need to come from that. Obviously making sure you have regular policy reviews, whether that, and looking at, is your schedule of review often enough? Is it every 3 years? Is that often enough, or is it too long to encapsulate changes such as this and any other changes that might come through? And I think one of the real things here is, don't just look at your policy and stick a new date on it. And I'll come back to that later, but really making sure your policy is fit for purpose and not stagnant, and is up to date with terminology and kind of what is going on in the world in relation to that. And again, I will touch on that a little bit later. Documenting changes. Obviously, you need to know what your policy was at the time an incident took place, and understanding. So obviously keeping archive records of previous policies, what the changes were, and potentially if necessary, why. And with that, embracing the digital age as to the dissemination of the policies. It's gone are the days where there used to be a printed handbook in a cupboard somewhere that an employee could go and read. Obviously, you've got your intranet, you've got webinars, you've got workshops, you've got so many ways that you can send out this information to employees, and the method and of that for that, whether it's here is the new PDF of the policy, for example, or actually here is a talk from someone of the key points about the policy, or here is a pre-recorded webinar we've done on this which has the key information. So it's again looking at how you can get all of your employees on board with this as quickly as possible, and obviously understanding where you're embracing the digital age. Are there actually people that don't really use technology in the workplace? There are still going to be some people that might actually have an email that they check once a week because of the nature of their business or the work they do for you. Classic example, grounds maintenance. They're usually out and about actually maintaining your land, and don't really check their emails on a regular basis, and might only check to say, oh, here's my email that says I've been paid and my payslip's ready. So encompassing how you're going to work with those people to make sure they're also brought up and taken on board with all these changes. So quickly having a look at some old, well, relatively old case law, in the sense of obviously before this act came in, it kind of does feed on some of the points that or touch on some of the points that I was mentioning earlier. So AB and Royal Borough of Kingston upon Thames. This related to Miss AB, who transitioned while she was at her employer. And she transitioned and informed her employer 8 months prior to doing so. And the main element of this case was that she felt that she hadn't been supported by the council, suitable policies hadn't been put in place, and effectively she was given no support during her transition. And also alleged that when she transitioned, people's behaviour changed from her. An example of that is on the screen, is when she said, it said, or if you wanted to get her away with having a hissy fit again. And this was in relation to a project she'd been involved in. And I think she'd raised certain concerns about it. And effectively, the senior manager were quite degrading in relation to her alleged behaviour. And she felt she had been singled out, and there was a witch hunt against her, and effectively the business was trying to get her to resign since she had transitioned, and obviously that she potentially might look at leaving, and a constructive unfair dismissal came. So it was quite a complicated matter in relation to this. And obviously some other ongoing issues in relation to this. Like, one of the big mistakes that the council had actually made was it took them 2 years after she'd actually transitioned to update her ID badge. So it still had her old name on it. And there were several other issues going on. And when AB raised concerns, management basically ignored them. They didn't do anything to investigate them properly, and effectively tried to accuse her of all the behaviours and making baseless allegations and demand an apology. So effectively trying to say it's not our fault, it's actually entirely you. And the council systems were not updated, and effectively just dead naming her. For those that aren't aware of what that is using someone's old name, certainly in relation to someone who transitions, or in some situations identify as non-binary. They might change their name to find a name that they think is to them who they are and identify as, and then referring to them from their old name is effectively dead naming. And AB effectively ended up bringing claims for discrimination on grounds of gender reassignment and less favourable treatment. Now, obviously, this in of itself isn't really an harassment claim, but it leads into what the council didn't do in relation to its policies as kind of a please don't do this sort of situation. So effectively at the tribunal, the council admitted its policies were grossly out of date and did not handle the transition well. So for example, there was a quality and diversity policy. It had last been updated in 2018, but there was a dignity and work policy as well from 2006. So again, some things were significantly out of date and probably just not fit for purpose. For example, that it referred to things such as sexual harassment being protected under the Sex Discrimination Act, and obviously that act was repealed and subsumed into the Equality Act 2010. And so again, things were significantly out of date, really not actually up to date at all as to let know names, but actually what the policy was trying to talk about. And also the e-learning was again a concern, and this goes back to the point about your e-learning, what do you do in relation to monitoring it, and the council confirmed, well, basically it goes out, and then if it's not done, managers are asked to chase, and it was kind of left at that point. So it's like, what do managers do if they don't chase, or what does the business do if managers don't chase, or what do the business do if managers do chase and the employees still don't do this sort of mandatory training? It's kind of the compliance and understanding fell down at that point. So again, the council really didn't have any chance of using the all reasonable steps defence. So the tribunal found that the council had failed to incorporate the Equality Act's obligations into its policies in effectively any shape or form. And therefore AB succeeded in her discrimination case. And what the tribunal said was that the council's policies and practices were in fact woefully inadequate. And it did find that it was not necessarily direct discrimination, but part of a wider and unexplained issues in relation to HR failing to actually investigate. And that obviously there were serious concerns in the fact that policies were not up to date and looked at or even really considered appropriate anymore. So I think it's more just a warning for employers as to making sure your policies are actually fit for purpose. And unfortunately, I think that's also, the council in this session, or this case, had really dropped the ball and let things lie for a number of years. But I think obviously what's happening at the moment and how things are progressing quite quickly in certain areas in relation to protected characteristics, policies can go out of date faster than people can realise. Even training can go out of date faster than people can realise. And I think that's just the key takeaway from this case is actually are everything up to date? Are you capturing what's happening right now? Obviously, law changes a little bit more slowly than the world does, but again, looking at that, and I think that again was the up-to-date and periodic review of these policies probably wasn't where it should have been, and needed to be happening more regularly. Even if that outcome is actually we have looked at this properly and there are no changes at the moment, that is acceptable. But going forward, that might be, well, we need to look at it again in 6 months because we know something's on the horizon, or actually in a year because we can think that something might be on the horizon, for example. Training managers and HR on the actual policy itself and what they need to do in regards to that policy in relation to the job role that they hold. And ensuring that your systems are prepared to deal with training, recording it, and obviously actioning either training that's not been done or someone who has failed training. And I think, again, that's something to be aware of. If people actually fail the training, that something else needs to be done. There were some other lessons out of this case, but they were mainly aimed around employees who were transitioning at work in regards to having your name changed on the system to reflect what your new name was. So there are quite a few things that came out of this case. And then secondly, another case, and this one a bit more was on harassment, but related to race. Mr. Galen worked for Ally Limited, and pretty shortly he was there for just shy under a year. At the time of his dismissal, he raised a complaint that he'd been subject to racial-based harassment by another employee, and that he had reported these remarks to manager, and also that there were other people who had overheard the racist remarks being made and didn't do anything to stop this sort of behaviour going forward. And obviously, he then brought a claim related to harassment based on race. The company argued that obviously it had taken all reasonable steps to prevent harassment in the workplace. It had an equal opportunity policy, it had an anti-bullying and harassment procedure. These policies had recently been updated. They were February 2006, and the harassment training to their employees had been done roughly in 2015. So they're arguing very recent, and therefore they had done everything they could to possibly stop this. The tribunal rejected this because they actually looked at the training and considered whether it was appropriate. And what they said here was it was clearly stale, and that a reasonable step would have been to refresh the training. And this goes to the point I was saying earlier of don't rubber stamping it of, oh, we've just stuck a new date on it, it's fine. The training that was actually provided was years out of date, even though they had just updated it in the sense of provided it to their employees again. It was mentioning several things that had moved on. I think he even got to the point of using certain terminology that at the time was acceptable, had since become unacceptable. And ultimately, they said that the reasonable steps defence failed because the training wasn't fit for purpose, so the employer hadn't actually discharged its duty. And at that point, he was awarded £5,000. Obviously, they appealed to the EAT because they weren't really happy about this. And the EAT kind of agreed with the tribunal and basically said that the training was of such poor quality that the training was no longer effective. So the EAT upheld the discrimination claim. So again, really the key takeaways from this is showing that you've actually done effective training and how you're going to record that, and that your training is up to date, that your policies are up to date, and you can show effective communication with your employees on this. And I think the certain key point really, I think, is around it no longer being a tick box exercise if your employees have passed it. That part to a certain element is fine. It's in relation to those that don't do it on time, that fail it, that don't even do it at all. You need to be really tackling those sorts of issues. And whilst it's only sexual harassment that the positive duty is coming in on, I think it will slowly lead the way that tribunals will be thinking of, well, just because it's sexual harassment doesn't mean other harassment is kind of, oh, it's only a redress rather than preventative. I think it's something to potentially be concerned that all of it could go forward. I know sexual harassment is the one that has been targeted by the previous administration. And it's simply not enough to just redate your policy saying we have reviewed it. If obviously you have reviewed it and there is no needs to be needs no change, sorry, then that is okay. You have properly reviewed it. But if it needs change after review, obviously implementing those changes as quickly as possible, and the bigger the change is, the more dissemination of that down to your employees as quickly and as effectively as possible. So just kind of retouching on all of that, I think obviously I've said it several times now. It's obviously reviewing and updating your policies and keeping this a regular thing. Training and awareness, training at all levels, how to spot sexual harassment, how to spot the early signs of it, and I think management and so on is important. Yes, Julie.
Hi, David. I was just thought I'd just bob in there because I think it's really important also to take this in context that employment tribunals will expect as a bare minimum that local authorities will have all the policies and procedures in place and will update them, but they're going to be expecting you to do far more to ensure that they are in place. And I think in terms of the reviewing the policies and procedures, that goes without saying, that should be done on a regular basis, but the training should start from induction. It should be really clear in induction, and it's not this, oh, tick box, yeah, I've read it. It needs to be more than that. It needs to be, I've read the policy, I've understood it, and there's been some sort of discussion about that understanding. The training is done at that stage. It's rediscussed in the probationary meetings, equality and diversity. What do you understand about that? Things like that. Have you done the training? What do you think about what we've got in place? Just having those discussions to show that it is always on the agenda. Have it raised in appraisals. By the way, have you seen that there's new updates? Have you looked at them? Have you done your training? Have you, these sort of things. If there's any changes to policies and procedures, any changes, any announcements, there's an announcement. All managers are tasked with raising it in the one-to-ones, raising it in team meetings, and there's some sort of log of that, because there's no point doing it unless you can record that you've done it. So you need some sort of log of how you disseminate that information down.
Brilliant, thank you. And also I think explaining it in your policies what sort of behaviour is and isn't acceptable, and obviously it will never be an exhaustive list, because I think the policy could go on to challenge some lengthy novels, but certainly I think banter is still used as an excuse for poor behaviour. Oh, it's only banter, I didn't really mean it, or that's just how they are. It is excuses that need to stop and should have stopped years ago. So I think explaining what you consider as an employer is banter, and that is not an excuse for poor behaviour, and certainly in relation to any form of harassment based on or sexual harassment, it's almost impossible for banter to really be involved in that. I think that's certainly going to be the view of the tribunal, and it will take an awful lot to dissuade them, if at all, from that of, oh, it was only banter, that we were joking about X, Y, and Z's, looks or the way they dress. I think a tribunal is going to look at you in an employer if that sort of behaviour is being either allowed or not tackled very poorly, because I think that it certainly is that it shouldn't be there. So I think just that's part of it. And as Julie said, the training throughout an employee's lifetime with an employer, it doesn't just start at induction and end at induction, it goes all the way through. Yes, Julie.
I think it would be useful to check out whether everybody should receive training on equality and diversity and harassment, and that be updated regularly. But potentially you should be looking at enhanced training for managers, because they should be, one, not participate in anything that could constitute harassment, etc., but should also be able to spot signs within their team, and be able to deal with it, and should also obviously be trained in investigating it, because quite often you bring a manager from a different team in to investigate any specific grievances. So enhanced training for managers on actually dealing with it, and enhanced training for your HR team in actually supporting them in that.
Yeah, brilliant. Thank you very much, Julie. And then lastly, really, clear reporting mechanisms and establishing those is always going to be important. And I think it's doing as much as possible to try and just dispel any myth there might be of fear of retaliation for reporting these things. You know, we still hear people go, I didn't report it because I was scared to lose my job. And I think it's, you know, establishing multiple channels for reporting, so that there is no just you've got to go to one person, and making sure that that's diverse. You know, there's still going to be an element of you know, if a woman who feels that she's been sexually harassed by a male employee, she doesn't necessarily want to go and talk to a male employee about that, and vice versa. And obviously also if it's same-sex harassment, you know, a man, woman or woman, they might actually not want to talk to a manager of the same sex as the person that's allegedly harassed them. So finding multiple reporting routes to getting them in there, and this inclusive culture, and of respect and understanding, because obviously you actually have that, you're less likely to actually have these instances taking place in the first place. So yes, thank you. Julie.
I think also it's really worth bearing in mind that this isn't a freestanding claim, so you can only bring it if you've got an allegation of harassment. And so people bring claims to the employment tribunal if obviously they perceive that they've been subject to harassment, but also if they're unhappy about how that's been dealt with. And so as part of your review of your policies and procedures, I think it's really important to take into account what type of behaviour leads people to bring tribunal claims, and it's not being taken seriously, not feeling comfortable in raising issues, delays in investigations is a massive one, and we see it really regularly. Not being kept up to date on investigations, and then expected to potentially work with the individuals while it's ongoing. And therefore, these are the sort of behaviours that lead to tribunals. So it's really worth, as an organisation, looking at those and thinking about ways that you can ensure that that doesn't happen within your organisation. It may be, and I appreciate most of our clients, the HR team, they are overloaded with work, and therefore if there are delays in answering issues, it's because of the amount of workload rather than the lack of thought. But it may be worth considering whether you have specific people within your HR team that are specifically receive enhanced training to manage discrimination, manage and support discrimination processes. And with that training, they will then be open to having those initial discussions with the individual. How do you want us to deal with this process? What information do you want as we go along? That sort of consultative process. As David said, consider having champions and advocates, and at that early stage, talking to the employee raising the grievance and say, we have these people that are trained up to support. Do you want us to get them involved? Do you want us to facilitate getting someone involved to help you? And that person can advocate on their behalf. The risk assessments is obviously obvious, but the facilitating discussions about what the next steps are, for really thorough investigation, and and not make the findings that someone is expecting. But you really need to think very carefully about what the next steps are, because anyone bringing a grievance against somebody within their own team causes a relationship breakdown. So what are you doing from the outset to minimize that breakdown, and what are you doing at the end to facilitate and mediate and resolve matters? And I think it's those sort of processes that communication, that facilitation, that treating people as a human rather than as a this is a process, let's go through a tick box exercise, will stand you in really good stead to avoid the tribunal claim in the first place. But then if a claim is brought, the tribunal will consider that you have got in place a really good mechanism for supporting people.
Brilliant, thank you, Julie. And I think also just one thing really for employers to be aware is, with the previous administration and possibly with the new administration going forward, timeframes for employers to actually deal with matters are always decreasing. An example is the flexible working one having dropped from 3 months to 2 months for you to deal with them. Time pressures are always going to be there, and I think it's looking at, can these teams deal with these things effectively and promptly, as kind of Julie was saying. So that brings the end really of what we were going to talk about today. So thank you very much for attending. We are taking a break as normal in August this year, and we will be back on the 25th of September for our next Sharpe Minds. So please keep an eye out for invites from that. But if anyone has any questions before they go, please do put them in the chat or email us afterwards, and we'll certainly answer those as quickly as possible. Thank you.
There is a question. Is there any statutory guidance on the bill available?
I have not seen any, but I would not be surprised if there's not some somewhere, or if not, the Human Equalities and Human Rights Commission will certainly be putting something out. We will have a look, and obviously when these slides go out, we will, if there is any, provide the link to the statutory guidance in that as well. So thank you.
I should also say we did get a question beforehand, didn't we, David, about how this new code would impact on volunteers. So first and foremost, volunteers aren't considered workers, so don't actually have any protection under the Equality Act, which seems quite strange, doesn't it, that you go and give your services for free, and someone can discriminate against you willy-nilly. But that is the current situation. They're not considered workers and therefore wouldn't have any protection under this. However, volunteers will, you should really consider very carefully how you treat volunteers, because it doesn't take too much, especially if they're long-term volunteers, for someone to put together an argument that actually they're a worker. And then, one, they should be treated as a worker and get minimum wage, but two, that they should have protection under the Equality Act. The other point is, I've seen quite an ingenious suggestion, and I haven't seen it play out yet in the tribunals, but I would try it if I was a volunteer, is to say that, I'm not bringing a claim as a worker, I'm bringing a claim because the organisation is offering me a service. They're offering a service, and the manner in which they're offering that service to me, as in the service is the being able to do certain work, the voluntary work, the ability to get work experience, etc. The way they're offering me that is discriminatory, or they're harassing me in the manner in which they're offering it. And so that is sort of a way around it potentially. As I say, I haven't seen it run yet, but I can see why it would run, and I can also see why, in front of the right tribunal, they would jump on the opportunity to ensure that individuals, especially if there are clear-cut allegations of unreasonable treatment, why they would try and find ways of offering that individual protection and a declaration that they've been subject to harassment. And so I think, from your perspective, just the fact that volunteers aren't covered under the Equality Act does not mean that you shouldn't be ensuring that they have equal treatment and ensuring that you prevent harassment of volunteers. You don't have to, obviously you don't have the same duties to give them the training that you give other people. But having said that, what you don't want is that you have a number of volunteers who come in and sexually harass your employees, and the employees would say you failed to prevent sexual harassment in the workplace. You brought in all these volunteers and they're going around making inappropriate comments or whatever it is. So ultimately, you don't want to treat the volunteers as a worker, but giving training, so basic training that you expect the sort of code of conduct and values of the organisation that you expect everyone to abide by within that workplace is important. And I think it's something to consider. Definitely consider how you actually approach that in terms of whether it's mandatory or not, and that's probably a different question. David.
Sorry, it's more just to go back to answer Sarah's question, and thank you for your comments. I agree with you on that one. Is the Equality and Human Rights Commission has its old technical guidance on sexual harassment and harassment at the workplace, which was published in 2020. They are currently out for consultation on this as to whether it needs to be updated or changed in relation to this new law. That consultation is currently live, so we can expect a response or an update of their guidance pretty quickly in light of this new law coming in October.
I expect ACAS will also be updating
Yeah.
their guidance as well. So it's always a good idea to follow ACAS's guidance because the tribunal do apply it in other schemes, as you do know.
Oh, and there's a question on the ACAS one from in the chat, which is, what is the interaction between new uplift and the ACAS code of practice, uplift and deduction? Can a claimant get both uplifts? Is there an order in which these uplifts should be applied? I mean, ultimately, I could potentially see a situation where you could have both, yes, but obviously that would require disciplinary or grievance claim, a dismissal related claim where that code of conduct would have applied. And then you've also got an harassment claim where this new code or this new uplift would apply. So potentially, yes, you could. And I think it's as there has been recent case law in the last couple of years on the ACAS version of the uplift, for lack of a better name for it at the moment, where tribunals have raised the question or looked at the question of up to 25% and how that's worked out. I think it might unfortunately be one of those ones of yes, but we need to see what the tribunals and how they deal with it, because ultimately that is squarely within their remit as to how that is dealt with, and how the interplay between these two might work. And unfortunately, it might have to be we need to wait and see until the tribunals and certainly the EAT makes a decision on how those two will interplay with each other. But effectively, I could see a situation of yes, both could apply to one case.
Yes, there's no reason why they wouldn't. So if you have a situation where someone raises a grievance about harassment, and you fail to follow the ACAS code, so you failed to give them an outcome in writing, or you failed to offer them an appeal, then that is a breach of the ACAS code of guidance, code of practice in respect of grievances, and so there could be an uplift in respect of that, and there's likely to be some form of uplift in respect of that. The second would be that if if you've then if they then assess what you've done and you've failed to comply with this, then there would be another uplift. The order that they do them in, I don't think has been determined yet. There's obviously lots of the order of other sort of uplifts and reductions has been agreed in terms of ACAS uplift, POLCI deductions, or and contributory conduct, which order they go in. I'm not going to try and remember off the top of my head, but there is an order. It may well be that we will get some form of a guidance in respect to that from the tribunals directly. Alternatively, it's likely to come through case law, and you'll just have to watch this space, I think. Thank you. Unless there's any other questions, thank you, David, for that session. I think it was really useful. Hopefully we'll see you all in September. We will, if anyone has any any suggestions for the topic in September, now's a good time to pipe up and ping over your suggestions, and we'll have a bit of more time to put that into practice. And we have a wonderful summer if you've not already had your holidays yet, and look forward to seeing you then.